capstone, judicial restraint, totally unwarranted amid blatant constitutional violations. So, if you'd allow me to read the paragraphs, Attorney Sal.
Yeah.
So, 5.35. The fact that ICC proceedings are ongoing is of no moment here. Judicial restraint is still inappropriate because, as detailed further in Part 5 of this memorandum, the ICC proceedings are void for lack of jurisdiction. Deferring to such invalid foreign proceedings would only legitimize the executive overreach and betray this honorable court's duty to uphold the Constitution against such encroachments. 5.36. To be sure, upon careful scrutiny, the Rome Statute itself concedes decisive authority to Philippine courts as the competent judicial authority of the custodial state, not only on the legality of arrests but also by necessary implication, the validity of ICC jurisdiction itself. Consequently, this honorable court's determination on the legality of FPRRD'S arrest and on the presence or absence of ICC jurisdiction should prevail over any contrary view of the ICC. 5.37. Petitioner is not unaware of Article 119 of the Rome Statute, which provides that any dispute concerning the judicial functions of the ICC shall be settled by the decision of the ICC, or this honorable court's obiter dictum in Pangilinan versus Cayetano, in which it downplays the competence to interpret the Rome Statute with finality. The discussion below, however, proves the contrary. 5.38, Article 59 of the Rome Statute governs the handling of the arrest in the custodial state, or the state where the person subject of an ICC warrant is found. As shown below, Article 59 underscores the primacy of national law in effecting arrests and assessing the warrant's legality, with central role vested in the national court. So, Article 59, arrest proceedings in the custodial state. Number 1, a state party which has received a request for provisional arrest or for arrest and surrender shall immediately take steps to arrest the person in question in accordance with its laws and the provisions of Part 9. Number 2, a person arrested shall be brought promptly before the competent judicial authority in the custodial state, which shall determine, in accordance with the law of the state, that the warrant applies to that person. Letter B, the person has been arrested in accordance with the proper process. And letter C, the person's rights have been respected. Number 3, the person arrested shall have the right to apply to the competent authority in the custodial state for interim release pending surrender. Number 4, in reaching a decision on any such application, the competent authority in the custodial state shall consider whether, given the gravity of the alleged crimes, there are urgent and exceptional circumstances to justify interim release, and whether necessary safeguards exist to ensure that the custodial state can fulfill its duty to surrender the person to the court. It shall not be open to the competent authority of the custodial state to consider whether the warrant of arrest was properly issued in accordance with Article 58, Paragraph 1, A and B. So, 5.39, the consequence of Article 59 is that in a conflict between the ICC and the National Court concerning the legality of an arrest or a requested arrest, the National Court's ruling is supreme because Article 59, Paragraph 2 explicitly empowers the National Court to determine the propriety of the arrest in accordance with the law of that state. This inherently includes an evaluation on whether the ICC has jurisdiction to issue the warrant, whether under domestic law or the Rome Statute itself, if the custodial state is a state party. In the Philippine context, this would necessarily entail an assessment of ICC jurisdiction post-withdrawal and under the principle of complementarity, allowing the National Court to subordinate ICC claims to Philippine constitutional and statutory requirements. And 5.40, petitioner acknowledges that the ICC has interpreted the last sentence of Article 59, Paragraph 4. it shall not be open to the competent authority of the custodial state to consider whether the warrant of arrest was properly issued in accordance with Article 58, Paragraph 1, A and B, as preventing national authorities from examining the validity of the warrant of arrest, and by implication, the jurisdiction of the ICC in the Philippines. However, such limited judicial review would be inconsistent with Article 3, Section 2 of the Constitution, which voids any warrant of arrest not issued in accordance with its terms. Accordingly, Philippine court review of any ICC warrant of arrest will necessarily include an inquiry into the authority of the judge and the process he followed in issuing the same to test it against constitutional safeguards. 5.41. Finally, the Rome Statute provides no direct recourse to the ICC to overturn a national court, finding that it has no jurisdiction. In this connection, the ICC has not only acknowledged that national courts have primary jurisdiction for interpreting and applying national law. In the context of Article 59, it has also confirmed that the ICC does not act as a court of appeal on the identificatory decision of the judicial authorities. The ICC's remedies are restricted to a declaration of non-cooperation and potential referral to the Assembly of States parties under Article 87, Paragraph 7, neither of which can compel arrest and surrender. Accordingly, the net effect is that a Philippine court's determination on ICC jurisdiction is controlling and for all intents and purposes binding. 5.42. In sum, far from mandating judicial restraint, the Rome Statute itself, through Article 59, affirms the supremacy of a national courts in determining the legality of arrest and, by necessary implication, the validity of ICC jurisdiction. This honorable court, as the highest competent judicial authority in the Philippines, must therefore exercise its full mandate to review of the arrest, detention, and rendition of FPRRD and grant habeas corpus relief without deference to proceedings of an international tribunal with questionable jurisdiction. And 5.43, Attorney, judicial restraint remains unjustified even assuming arguendo that the ICC had jurisdiction to issue the warrant of arrest against FPRRD, while Rule 102, Section 4 of the Rules of Court provides that a writ of habeas corpus shall not issue when the person is detained pursuant to a process from a court with jurisdiction. It is a settled exception that such a court is deemed ousted of jurisdiction when a deprivation of a constitutional right is shown to exist. In such case, habeas corpus is the appropriate remedy to assail the legality of detention. Yan po, Attorney Sam.
Ang pinupunto po ng aking article sa Manila Times, kasi mayroong mga nagkakatwiran na dahil naumpisahan na ang court trial, ang trial sa The Hague, hindi na dapat makikialam ang ating Korte Suprema. Kaya kailangan daw magkaroon ng judicial restraint. Huwag na lang. Apart from sinasabing mutin academic na at kung ano pong mga bagay na yun po tinalakay na natin na kahit ng Korte Suprema, kahit ng mutin academic na, yung hinihingi mong aksyon ay hindi na may bibigay dahil nagawa na, nagro-rule pa rin ang Korte Suprema upang maging guidance sa mga institusyon, mga opisyales, mga abogado at ang buong gobyerno kung ano ang dapat gawin sa isang kalakaran na inilatag sa hukuman. Ngayon, yung pong katwiran na dahil nagsimula na ang hearing sa The Hague, hindi na dapat makialam ang Korte Suprema. And sabi po ng mga abogado ni Kitty Duterte, ni Veronica Duterte, unang-una, wala namang jurisdiction ng ICC. Kaya hindi mo pa pwedeng gamitin na sila ay nagbibista na rin. Kaya hindi na tayo dapat makialam. Unang-una dapat nga hindi sila nagbibista. Kasi nga walang jurisdiction. At kahit na yung Rome Statute ay sinasabi doon na pag merong mandamiento aresto na sila ay inilabas laban sa isang mamamayan ng miyembro ng International Criminal Court, kailangan immediately, kung may request sila, ang nire-request na bansa ay kailangan gumawa ng kaparaanan para maaresto. At ang unang gagawin nila, pagka-aresto, dadali nila sa lokal na hukuman para yung batas ng bansang yon, kagaya ng bansa natin, si Presidente Duterte, nung inaresto siya, dapat dinala siya sa hukuman na hindi ginawa. Kailangan kasi padaanin nyo doon kasi yun ang itinatakda sa ligang batas, na bago mo tanggalan ng kalayaan ng isang tao, kailangan padaanin mo sa proseso. Ang ibig sabihin ng proseso, maghahain ka ng demanda, ibigyan mo ng pagkakataon, ang inaakusahan mo ng kanyang karapatan na kontrahin ang demanda, na mabigyan siya ng isang abogado, at ang abogado naman ay maghahain ng mga legal remedies para sa kanyang kliyente, at ang akusado ay pwede niyang i-confront ang mga testigo laban sa kanya, at meron din siyang karapatan na maghain ng kanyang depensa. Yan ang sinasabi ng ating saligang batas. At yun din ang sinasabi ng Rome Statute, na kailangan padaanin mo yan doon sa hukuman ng bansang miyembro na nire-request mo na arestuhin yung akusado. Pero hindi nga ho nila ginawa yun eh. So kahit na saan na padaanin, whether sa konstitusyon natin, whether sa Rome Statute, talagang illegal ang ginawa. Walang jurisdiction. Tandaan niyo, gaya ng pinaliliwanag ko sa inyo, noon pa ang International Criminal Court, hindi maarang basta pumasok pakialaman ang sistema legal, sistema juridikatura ng isang bansa na miyembro sa kanila. Bakit? Kasi mismong Rome Statute nagsasabi na kailangan merong principle of complementarity. Na ang ibig sabihin, papasok lang kami sa inyo kung wala kayong kakayahan na usigin yung mga akusado kriminal na lumabag sa krimen laban sa sangkatauhan o crimes against humanity. O kung meron ng kakayahan ng miyembro, ay hindi nyo ginagawa. Madalit sabi, yun ang kondisyon. Yun lamang ang kondisyon na maaaring makialam ang International Criminal Court. Gaya na unang sinabi natin, meron nung tayong kakayahan. Libo-libo na inusig natin, libo-libo na napakulong, 3 presidente ang yung isa tinanggal natin, yung 2 pinakulong natin. Ano pa bang pruweba na tayo may kakayahan? At yung naman sasabihin na meron kayong kakayahan pero hindi nyo usigin, papasok kami. Ngayon sinasabi nila, hindi naman nausig si Presidente Duterte kasi may immunity siya. Kaya daw sila tumakbo sa ICC. Well, ipagpalagay na natin, nung presidente siya, hindi ka po pwede magdemanda sa kanya. Pero 3 taon na nakakaraan, wala hanggang ngayong demanda. Walang nagdidemanda sa gobyerno, kahit na sa pribado, wala. Madalit sabi, nung tinanong ang gobyerno, yung mga tagapagsalita ng gobyerno, bakit hindi kayo nagpapail 3 taon na? Kasi wala namang ebidensya. Wala palang ebidensya. Ibig sabihin, hindi totoo.